The purpose of this video is just to give you some really basic information about what a statute is. Some of this might be already clear to you, in which case that's great. But if there's anything that you need to clarify before we move further into the process of statutory interpretation, you might find this video useful. So, what is a statute? The word statute is sometimes used interchangeably with other words like enactment or act or legislation. Typically, these all mean the same thing. We've also talked to you about what we call delegated legislation or regulations. These are statute-like instruments that are made by members of the executive because Parliament has authorised the executive to do so. At one level, these words, act, enactment, statute, legislation, refer to the actual artefact that is produced by Parliament. A physical copy of the bill that is enacted by the House of Parliament as law is stored at Parliament House, and electronic copies are available online. So when we use this word statute, we refer simply to that thing. But more broadly, we mean the content of the law that statute contains. Now, it is very common to describe a statute as a law. Sometimes these words are used interchangeably, but it is really more accurate to say that a statute is a source of law. It is a statement setting out what the law that applies to a particular subject is within the territory to which that statute applies. The process of statutory interpretation is the process of figuring out the law that the statute has created. Legislation is not permanent. Generally speaking, it can be repealed or amended simply by enacting another statute. One of the important exceptions to that is those special statutes that are the constitutions. The Australian Constitution and the state constitutions are just statutes like any other. But there are different rules that apply to determining when they can be changed. Remember, we told you that at the state level, it's generally possible for state constitutions to be altered in the same way as any other ordinary statute. But the position at the federal level is different. The Australian Constitution sets out that statute can only be altered by a special process that involves a referendum. When legislation is enacted, an amending act is enacted. That legislation will set out the changes to be made to the principal act. Over time, a consolidated version of the statute will be produced that sets out the statute in its current form. When we refer to a statute, we mean, strictly speaking, only the text that makes up the statute itself, that has been debated by the two Houses of Parliament and ultimately enacted as a law. But sometimes during the process of statutory interpretation, we refer to what we call extrinsic material. This can include things like records of the second reading speech in which the bill was explained before Parliament. Another kind of extrinsic material are explanatory memoranda, which are typically compiled by the Member of Parliament or Department that proposed the legislation in question, and which, as the name suggests, are an attempt to explain what that statute does. In some jurisdictions, there is an additional requirement set out in a Human Rights Act that requires Parliament to prepare a statement of compatibility, which sets out whether the statute is compatible with the rights protected by the relevant charter, or if not, why it thinks that the incompatibility is justified. Now, this extrinsic material is publicly available. It does have some role in statutory interpretation, though as we're going to see, the emphasis that we place on this material is heavily constrained. We'll talk more about that later, but in essence the reason for that is that this extrinsic material is not part of the statute and it doesn't have the force of law. We've already talked to you about the relationship between statute law and other sources of law. Specifically, we've explained to you that statute law is a superior source of law. In particular, it's superior to judge-made or common law. But there's an important complexity to introduce to you here that we're going to talk about in detail later. That is, that most of the principles of statutory interpretation that we look at in this course are common law principles. There are some statutes that set out the way in which legislation should be interpreted. One of the most important of these is the Acts Interpretation Act, which we look at later. But for the most part, the rules of statutory interpretation have been articulated and developed by the courts. They are not set out in legislation. They are not set out in the Constitution itself, though they are said to reflect its structure and the constitutional relationship between the three branches of government. So it's Parliament's role to make statutes law, but it's the court's role to interpret it, and that will be done in accordance with principles of statutory interpretation, which have been predominantly made by the courts. It's important not to get carried away here. The fact that most principles of statutory interpretation are common law principles doesn't mean that statutes mean whatever the courts want them to, nor does it mean that the power of the courts to interpret statutes is unconstrained. We've already talked to you about the fact that when interpreting statutes, courts must remain within the constitutional boundaries of their power. More specifically, the Australian High Court emphasised that the court's ability to craft principles of statutory interpretation is constrained by the Constitution too. In order to be legitimate, the principles of statutory interpretation must reflect the constitutional distribution of powers between the legislative, executive, and judicial branch. This will make a little more sense to you later when we turn to look at what some of the specific principles of statutory interpretation are.